Hello, Gaurav sir, can we start? Can we start?
He has already given go ahead. Whenever you will start, he will speak.
Yeah.
Okay.
Hello, good evening, everyone. Thank you for joining us today for this insightful session on awareness and strategic approach for securing intellectual property rights. At ArtPark, we are committed to empower and upskill the startup ecosystem with knowledge, insights, networks, and resources. Today's topic is particularly relevant for anyone who has an innovative idea or innovation but doesn't want it to be stolen. We are thrilled to have Mr. Gaurav Chivar, advocate and
This
partner
meeting is being recorded.
in Chadda and Chadda, an IP firm, as our speaker today. Mr. Gaurav holds an extensive experience in conducting awareness sessions, workshops for colleges, teaching institutes, and industries about different aspects of intellectual properties. His expertise involves identifying, directing, and protecting IPs for different technologies in different fields. We are privileged to have him share his expertise on our platform today and provide actionable insights for ideators and innovators navigating the complex world of IP protection. So, before we begin, let me quickly set the agenda for today's session. Mr. Gaurav will share his insights and strategies for approximately 35 minutes. This will be followed by a live Q&A session where the main discussions and interactions will begin, where you can also ask your questions directly. The session will conclude with some actionable takeaways, closing remarks, and a lot of confidence to work on your idea. We have also have a hard stop at 7:15 p.m. today. So if you don't get a chance to speak during the session, please do write in the chat box. So please free to drop your questions in the chat box and we will try to answer all the questions right away. Please make sure you post your questions in the chat box beforehand. So, without further ado, let's welcome Mr. Gaurav Chibar to the virtual stage. Mr. Gaurav, over you to sir.
Hi. So firstly, thank you so much for having me. Uh, just to tell you a brief, like um, my name is Gaurav Chibba, like as she has mentioned, and see, 35 minute. Let me tell you very frankly, is too not so much of time where I can cover this thing in a very broader way. I'll try to touch upon on a few important points, important topics, and maybe we can discuss a few important points later during the Q&A session, right? So just to give you a brief about myself, like I started my uh, engineering. I did my engineering in
ಇಲ್ಲ
electronics
ಇಲ್ಲ
and communication.
ಇನ್ಫಾರ್ಮೇಶನ್ ಮೀಟಿಂಗ್ ಇದು ಸೊಲ್ಲ ಏನದು
Am I audible?
ಕಾಟೆ ಕಾಟೆ ರೀಲ್ಸ್ ಕಾಟೆ
Yeah.
ಕಾಟೆ
All are requested to please mute themselves except the speaker. Thank you.
Right. So
ನಾವು
then I
ವಾಟ್ಸಪ್
did my
ವೆಬಲ್ ಆಗಿ
law,
ನಾವಲ್ಲ
and I was also a part of Tata Motors as in-house counsel, and then I'm working with this firm, Chadha and Chadha, as a
ಎಸ್ ದಿಸ್
partner
ಇಸ್
in
ಮೈ
the
ಫಸ್ಟ್
patents team.
ಆಲ್ಸೋ ಸಿ
That was just a brief
ರೀ ರೀ ರೀ
uh,
ರೀ
about my background, right? So without taking much time, I'll directly move to the topic here. One silly questions, like it's a very very silly in our industry in terms of IP. All I asked was, can I patent my copyrighted trademark? So ideally, this is supposed to be a joke, and if you are able to laugh on it, maybe then if you can't laugh on it, maybe this is the session for you. A small clip just to tell you that intellectual property is not something alien for everyone here. We are surrounded by intellectual property. It's not very hardcore science. It's not very, alien terms. It's not like that. It's just that we are not much aware. So we feel that this is something very difficult. Trust me, at the end of this session, uh, your clarity will be very good in terms of understanding IP and what all types of IP and how you can strategize accordingly. For example, if you see in this video, we are surrounded by IP, geographical indications, copyright. Uh, for example, the bottle he is opening. So what you can see here is design, and then there's a logo, trademark. We see IP in our day-to-day life. The glasses we wear, the t-shirt we wear, the phone we carry, the fruits or the food we eat, all form of IP. It would be good if I can, it can be muted because yeah. So like I said, we are surrounded by intellectual property rights. And first thing that we have to do right now is forget about whatever ideology we have, forget about whatever clarity we have, forget about whatever confusion we have. Let us start fresh. Okay. I'm assuming for this session that I'm going to skip all this. I'm assuming that you guys are not at all aware about IP. I'll consider you at zero level, and then I'll try to explain different aspects of intellectual property rights. So, whatever you were doing, whatever mindset you had, whatever thoughts you were having just before this session, let's keep it outside. Let's start afresh. Okay, like we go to school, right? In class one, we are very fresh. Let us do it that way. Let's keep it very fresh here. Now, what is intellectual property right? Okay. Intellectual property right, if I explain you in a very simple term, intellectual property right, we have three words: intellectual property right, that is inside our brain. So you have some ideas, what you have some concepts, you have something in your mind, that is what makes it intellectual. So if it is inside your brain, it is intellectual. You take it out in the form of any property. For example, you write it down, you created a product out of it, that forms your property. And when you get a right of it, ownership or legal right, that forms a right. So intellectual property right, it works in these three terms. So like I said, if you have an idea in your mind, you have a concept in your mind, it's not your right, it's just intellectual. You don't get an ownership. Like, some people say many times that, oh, I got this idea 10 days back, so it should be mine. But no, it's in your mind, it's just intellectual. It's not property, it's not right, it's just intellectual. You bring it out, we'll rework on it, we'll rephrase it to form a proper, the requirement of a law accordingly. And then when you get an ownership of it, you get a right. So intellectual property right, that's how it works. Patents. So patent is one form of intellectual property right. Keeping it brief, it is for technical implementation. So you have a technical problem, you're solving a technical problem, you're providing a technical innovation, right? So those things goes for patent. Trademarks, brand name. We will discuss all these things in detail. Design, visual appearance. It has nothing to do with technology. There are some confusion with people that, I can go for patent and I can go for design. What is the difference between that? Patent is full of technology. It may not be related to your shape. Design, just appearance. Copyright, your creative, literary, or artistic work. For example, you write a software, you draw an art, you create or you do a movie, lyrics, so all those copyrights. Semiconductor IC, layout design. When you have this motherboard, you try to create a design over it. That is what is protected under this law. Geographical indication, mangoes, or we say chappal, sari, that is particular to a particular geographic location. That is what is protected under geographical indication. Okay. Advantages of IPR. I mean, many of you may be startups, or many of you might be going for funding right? So what is the first thing that they ask you? Do you have an intellectual property? Are you serious about your project, right? So that is what gives you an upper hand. You have a new product, you want to launch a product in the market, you want to create some difference in the market. Intellectual property will give you that upper hand in terms of brand. Let's say I want to start a food industry based product, so I have a brand name. Is it protected? Did I file for it? If you don't, anybody can come into the picture and copy it. You can't protect, you can't stop them. In terms of software, in terms of patent technology, if you have that technology, you can create an edge. You can create that boundary so that your competitor cannot enter easily. So it safeguards your ideas, it empower innovation, and this is what makes you unique. It turns innovation into market leaders. Let us say I came up with a very good, interesting battery swapping technology, which is much better than what is already existing. I don't go for IPR. What will happen? The day you launch it in the market, the very next day, your competitor will come into the market with the same idea that you're doing. Your market is gone. So there was a thought a few years back, I would say 5-10 years back, when we say that what's the advantage of going for a patent? What's the advantage of going for trademark or any form of IP? The courts are so lenient. Everybody is copying everything. So why should we go for that? Things are changing. Let me tell you very frankly. The high courts, Delhi High Court, Mumbai High Court, Chennai High Court, Kolkata High Court, they have specific IP based division. You can see in front of you, there are many landmark cases where the penalty to the damager is very high. For example, in case of Pfizer, USD 240000 damage, right? It's very big amount, 26 million in terms of Mobi antenna technology. Lava, very big case, you know. So gone are the days when you can simply copy and go into the market. No, courts are very strict. Courts are very IP friendly. So if you are an applicant, you are very genuine IP guy, you have a product and you're actually being suffered because of the copy, courts are there for you. Things are changing. It's not the same law system that we used to have 5 years, 10 years back. Things are changing drastically. Some trends for you. So in terms of financial year 21-22, patent application filed, as you can see, like 66,000 was of application filed, then become 82, and now there's an increase by 24%. So I'll skip all this thing for the time being. Yeah, strategy. Okay, this is very important point. Why I wanted to cover here is, what happens is, whenever we want to go for a market, I mean, we want to go into a market and launch a product, what is the first thing that comes to our mind? Let's launch it, right? Let's launch it. Let's prepare the market strategy. Let's prepare the financial strategy, and let's rock the market. That's it. No, point is we should see the perspective of IP as well. There is a problem that when we enter into a market, we don't know if it is somebody else IP or not. The major problem. There's a big landmark case for that. I'll talk about that later. Second thing is, we don't strategize our IP. You have a product. That one product can have multiple forms of intellectual properties. We must strategize it beforehand, before you talk about launching into a market. You have a product, let's say if it is IoT based, you can have a software. Software can be copyrightable subject matter. Let's say you have a packaging, it can be a design subject matter. Let's say you have a logo for that, it can be a trademark based subject matter. You have a technology involved in that, can be patentable. We'll study that. So this strategy has to be decided beforehand, even before you go to an investor, because if you go to an investor, these are the basic questions that we will ask. What kind of protection you have on this? What are the different kind of ownership you have on this? Then protection of core innovation. What is the base? What is the core innovation you have? When you go for a patent is given for 20 years. Now you want to protect the core innovation. Modification can happen. Like today is something, then 5 years down the line it will be improvised further. 10 years down the line, again changes are gonna happen. Monitor IP trends. For example, when we enter a market, we don't see what our competitors are doing. We just see that they have launched this product. IP, okay, let me give you an example here. I'll quote one example from my previous organization. What we used to see is that uh, a competitor is in the market. He has launched a product now, right? For that product to be in market now, the IP work must have been done 4 5 years back, even more than that. Today, if I'm working on something that's already in the market, our competitors have already filed improvement in terms of patents, and they're way ahead of us. We need to understand that landscape. IP will come first. You will see the publication from your competitor first, then their product in the market. So we need to understand how the trends are going. Your competitor, I mean, for example, in terms of, if I say vehicles, are they going into EV? Are they going into battery swapping technology? How many patents are they following? So that gives an upper edge to identify the trend where this industry is going. Instead of waiting for them to launch a product, we can, go through this way also. But of course, enforce and defend. You have a really good technology, you have an IP of it, you can anyhow defend it. Some common pitfalls. Whenever you have a really good idea, like I remember interacting with somebody long time back. He said that I have a really good idea. Let us see if I can, commercialize it, or I can, get funding for it. And I disclosed it straight away. Point is, you did not protect your IP. You just disclosed it. As a result, your um, financer, your funding guy, or maybe your colleague, or maybe your friend circle, or somebody also like that idea can start working on it and can file IP before you think about it. So if you have an idea, if you have something in your mind, first try to focus on intellectual property. I mean, have a picture of it, and instead of directly going for that. Secondly, the inadequate understanding of, in terms of patents, if I say in terms of trademark or copyright, understanding of the, law. So if you do not have understanding of the law, you will end up committing some basic mistakes like, inadequate spec drafting, or insufficient disclosure. Once you file a document, you are done with it. You can't go back and refile it, right? So you have to be very clear, what are you filing, what kind of, information you're disclosing to Indian Patent Office or Trademark Office or Copyright Directory or Design Office. One common problem that I've seen is in terms of patent skipping prior art search. I'll talk about it in my further slides. You can, let me know if I'm going too fast, because considering the time I have, I wanted to I would cover a few more
No,
important topics here.
don't worry about time too much. Okay, you go ahead with your this one. Okay, don't
Great.
worry
Okay.
about 35 minutes. Nothing like that. Yeah.
Right. Okay. Thank you so much.
I want it should be fruitful for our audience. Okay.
Right. Great. So I'll keep that in mind.
Yeah.
Now, so we understand what intellectual property is. Intellectual property is, intellectual when you have something in your mind, you take it out, it forms a property, you get a right over it, it's a right. So intellectual property right. The most uh, common, or most, I would say, many people finds it difficult to understand is patent. So I'll start with patent. Patent is a negative right. It is not to allow you to process or sell your product, but to stop others from selling a product. It's a negative right. Now, patent is given to an invention. Now the question comes, what is an invention? Okay, in this industry, even if I take the case of what I was going through in Tata Motors, or what I was seeing with other inventors or other people from different industry, we are confused with this term innovation and invention, right? We say, right, Eureka, I have a great innovation, right? This can, change the world like never before. So innovation and invention, we need to understand this concept first. Innovation is uh, something that is novel in nature. It is new. So that is just one criteria of being an invention. I'll discuss other criterias also. I'll go with the flow here. And inventions are patentable. All inventions are innovations, but not all innovations are inventions. Okay, we need to understand this thing. I'll come to this topic again. Let me just tell you, there are two types of inventions that we see in the market today. One is incremental. We say that I have, for example, if you see in front of you car, it keeps on evolving with years and years. It's not like one day, boom, you got something new. No, it keeps on evolving. So it's called incremental. 90 plus percentage of the inventions in today's world are incremental in nature. Somebody created, let's say, thing A, and I got another idea to improvise it to B. So I went to B. Then third guy went to C to improvise B. Right? So that's how incremental invention happens. The 10% is breakthrough inventions. So you see one example here. Another example would be, 10, 15 years back, we used to have mobile phones with buttons, right? All of a sudden, we saw that touch screen display or touch screen based mobile phones started coming into market. Out of nowhere, that's a breakthrough. Because you can't relate it to what it was available. Right? So breakthrough inventions. So my point here is that even if you have a small idea that you think that you can, give something to the society in terms of increment, don't neglect it. Think about it. Maybe you can, come out with something better. Or maybe that idea that you're coming in your mind to improvise, maybe it is good one. Now the question is my invention patentable? So we need to understand these 4 criteria first. First is novelty. Your invention has to be novel. Okay. Novel means absolutely novel, not at all disclosed anywhere in this world. In my earlier experience, I was interacting with one inventor. He came up with an example in terms of infotainment system of a vehicle. So he mentioned that I've created this kind of infotainment system. This is very unique and first time. I said, okay, very good. It seems novel. Then I asked him, is it novel here or everywhere in this world? Then he mentioned, no, it's there in US. It's commonly available. But in India, it's first time. So I'm bringing this to India for the first time. I'm sorry, no, it's not novel then. Novelty means absolutely novel. Nowhere in this world is available. You don't have to be, do the search to identify if it is novel or not. You just need to know that it is novel to you, at least. So rest of the work, we take care of it. As an IP guy, we do the parrot search if it is actually novel or not. Right? The The second criteria is non-obvious. I mean, we say in today's world, no, no, it is so obvious, right? We use this terminology obvious quite often in our daily life. So we need to see if that word is actually being used here or not. Obviously, it's for a person skilled in the art. Right? Not to me, not to you, but somebody from that domain, right? I'll explain more on this. Inventive step is more difficult to understand. I'll take a few examples to explain this to you. The third is industrial applicability. It should be capable of being used in industry. There's no point I create an invention which can't be used in the industry. It is just for my personal reason I keep it in my room. No, it won't work. It has to be capable of being used. And the fourth one is subject matter. In India, there are certain subject matter which the law says that are not patentable. For example, mere software is not patentable. Mathematical formula is not patentable. New form of a known substance is not patentable. Mere combination of two things are not patentable if their property is just a mixture of them, right? So if the answer to all the above question is yes, you have a patentable invention. Novelty must be new and not already known to public. Absolutely new. I mean, you can check IEEE publication, you can check patent publication, you can check news, you can check YouTube, anywhere in this world. If it is there before you file, it's not new. Inventive step. Now, I want your full attention here. Many times, I mean, most of the time, what happens is people get confused here. What is inventive step? The second most, the criteria for patentability is inventive step. This is what differentiates innovation from invention. Innovation is, it's new. Invention is, okay, it is new, but it has to be a non-obvious contributor. Now, what do you mean by non-obvious contributor? I'll take a few examples to explain this to you. It works the same in all the field, even if you are in deep tech, even if you are in health tech, even if you are in fintech, it remains the same. Non-obvious means for a person skilled in the art in that particular technology. If somebody is working in deep tech and for him, that particular invention is quite obvious, though novel, but obvious, then it's not patentable. So what we can establish here is technical advancement. It can be economical significance also. So I'm going to stick to inventive step for a few more minutes to make you understand this. The most famous approach that is accepted even in Europe, even in majority of the jurisdiction, that is problem solution approach. We will talk on this approach. So this can help you. Now, we can do multiple exercises here. You ask yourself, now when we were discussing, we are talking about many inventions here. Maybe you're coming in your mind that, this kind of idea I used to have. Is it novel? Is it inventive? Is it inventive or not? I'm confused. Okay, hold your thoughts. Let's not jump into that. Let's understand what problem solution approach is. First point, identify one problem that you're trying to solve. Identify what is the solution to that. Right? Just write it down. This is one simple exercise that you can do in your day-to-day life also. What is the problem that you're solving? There can be n number of problems. Stick to one. What is the problem you're trying to solve? The best one. What is the solution? Right? Ask yourself, okay, this is a solution. How I am achieving this solution? Is it because of some method? Is it because of some hardware structure? Is it a system? Is it some unique step? Is it a contribution from these three elements? Ask yourself, how am I achieving the solution? The point how is very important here. Then when you know how you're achieving this solution, again ask yourself, be honest to yourself, ask yourself, is this how part new? According to you, is it new? Just be, honest to yourself. Is it new? If it is new, okay, first criteria is set. Is it obvious? If it is obvious, no, it's not patentable. If it is not obvious, it is patentable. So that's how problem solution approach helps us to identify if my invention is patentable or not. Again, how will I know if it is obvious or not? Right? Many of you will agree with me that obviousness is very subjective. Very subjective. It can be obvious for me and may not be obvious for my colleague. Right? So how do I know if it is obvious or not? Let us do some exercise for this. Okay. This is a very old pin, right? Now I'm going to do the same exercise, problem solution approach based exercise. First point, what is the problem with this? Problem is when I try to have a stack of paper, it can't stack more. You'll have to pull these two arms apart then paper can be stacked, but you can't stack many paper, 1 or 2 or 3 or 4 maybe. And when you try to remove it, it may tear paper. Of course, you have corners that may, injure you. So you see a problem, fix one problem. Now identify solution. Okay, let us say this is your solution. The problem that I was trying to address there, one problem was when I tried to use the left one. The problem is it's not safe. If I'm sticking to that problem, it's not safe. The solution that I have here is it safe? Yes, because the open-ended are not completely open. They are closed in vicinity. So chances that it will break you is very less. So if I go with one problem and I go with another, the solution corresponding to that, okay, they are close to each other. Yeah, I can say it is novel, okay, because it's done. Is it inventive? Subjective. Let's hold your thoughts here. Let us say it is not obvious, because to show that it is obvious, I want an evidence. Patent office, what they do is when you file a patent application, they will cite some prior arts. Let us say document D1, maybe patent document D2, maybe IEEE document D3, some other document. And they will say that if I give the same problem to the same skilled person, let's say person ABC, and these 3-4 documents to him or to her, can he or she come to the same solution that you are coming from? If yes, it's obvious. If no, it's not obvious. So that is where we can focus. Is it obvious or not? Now, if I come to this particular scenario, okay, just to keep the content very simple, I'm using very generic examples, very generic. The concept remains the same in any field. Even if I go to deep tech, fintech, or education-based industry, anything, if I go, or chemistry or biotech, the concept remains the same. Now, the problem with this is, again, I'm not able to stack. I mean, it is efficient than the previous one, but it's still not able to stack multiple amount of paper or good amount of paper, right? So that is my problem. Okay, I'm trying to come to a solution. Okay, I'm thinking. This is what I find. I'm sure many of you have seen this already. Of course, if you haven't seen, I think maybe you can go to the market and just try to have an idea of it. Problem with the middle one is I'm not able to stack paper. Even if I stack paper, I'm not able to remove them efficiently. And even if I try to remove them, there's a chance that it will tear paper. Problem? Solution. Solution is because of these two arms and this V-shaped structure. Whatever you want to say, V, U, whatever you want to say. This structure, when I pull these two arms towards each other, it opens up. I can stack paper, I can put the paper inside that, and I can release it. It will keep it intact. Now, because of the one at the center, because of the one at the left, do you think it is obvious to come at the third? Don't think about now. Let us imagine as maybe 15, 20, 30 years back when this product was about to come into the market. That is actually very important here. When this product was about to come into the market, that time we have to see. If not obvious, it is patentable. So problem solution, problem solution. This is an example of incremental invention. Another quick problem, I mean, just a very basic one. See, you need to stick to the concept. Basic concept, don't forget, problem solution. Do you see a straw here? Yes. What is the problem? Okay, the problem is when I try to consume fluid using the straw, either I have to bend my neck, painful, or I have to bend the straw. If I bend the straw, the flow will be interrupted, and I may not be able to consume it efficiently. Problem. Our world is filled with problem, and whenever there is a problem, we have opportunity. Solution. That's the exact pattern. It's actually a US granted patent, but it got expired in 2018, I guess, 18 or 19 or 20, something like that. I don't remember exactly. You can have a look at it. It's available at Google Patents site. Now, here the solution is the zigzag structure, very basic solution. If I look into this now, I may feel that, come on, man, this is so basic. What is so different in that? It's very, very basic. If it is solving a problem and it is novel and inventive, it is patentable. Doesn't matter how basic, small, or big incremental it is. Incremental invention, even if it is very basic, even if it is very small increment, ask yourselves, is the how part new? Yes, it is, because there was nothing like zigzag pattern for straw. Is it obvious or not? I mean, if I say it is obvious, I need to show something that it is obvious or not. If it is not, then it is patentable. So point is, don't hold your thoughts, right? You're not, you may be good with your technology, but whenever you have a thought about some idea, have a multiple thinking. I mean, you should do a brainstorming and ask yourself in terms of problem solution approach. Do you think it can give something really good to the society? Subjective. One last example. I mean, I'm sure many of you have seen this immersion rod, right? We use it to, heat the water that we try to use. This is how we do it. So there are two ways. One is, I mean, of course, you can't just put completely inside that, right? Otherwise, what will happen. So somebody did some jugaad, somebody did some crazy thought and come up with a solution to this. Now, drawback with the present scenario that you see is stick required to hang the heater. Now, problem, heater can be hanged without, heater can be hanged without any stick. Difficult. Okay. Heater with floating balls. Again, what this invention, what we see here is, they have this floating balls at a particular height. So this floating balls will float above the water, keeping only the immersion part responsible for heating. I don't need stick now, right? Some very small invention. It's not something, very, very great, I would say, very big, I would say, but it's solving the problem. Problem, okay, this is the problem. Solution, this is the problem. How part is floating balls. Solution is I can, use the immersion rod without using the stick, such that it is floating. But what is the how part? How am I able to achieve the solution? Because of the floating balls. Now ask yourself, is the floating ball with the heater is new? Okay, I haven't seen it anywhere. So according to me, it's new. Maybe IP guy can tell me later. Is it obvious? I'm not sure, because to be obvious, you can ask again yourself, what would have been the obvious solution and why is it different than mine? Obvious solution would have been to use a stick, right? Then I can say that my solution is not an obvious solution. So I can say it is in patentable. Industrial applicability capable of being used in the industry. Non-patentable subject matter, I'll just go through it briefly, because Indian patent law, restrict us from patenting certain technology or certain structure. For example, presentation of information is not patentable. Mathematical, business method, computer program per se, algorithm are not patentable. Section 3F, mere arrangement and rearrangement is not patentable. Mere scheme or rule of method of performing a mental act, playing game, is not patentable. Let me tell you, there are certain guidelines given by the Indian Patent Office. In what cases we can say that subject matter which is closely resembling to this can be patentable. Now, for example, if I talk about deep tech inventions, for example, software-based invention, certain things we can keep in mind. For example, am I solving a technical problem? No, I was only talking about problem solution approach. In terms of deep tech, I need to ask, okay, I'm solving a problem, but is this problem technical in nature? Then is there any hardware interaction? I mean, now not so much into hardware interaction, but the examiner in today's world, they ask is technical effect. Because of your solution, is it technical in nature? What is the technical effect that is being achieved? Right? So move your question from problem to technical problem. Solution, how part to technical effect. Right? These are the very basic questions you can ask yourself when it comes to software-based inventions. You know, CRI guidelines is computer-aided invention-based guidelines. IPO introduces it a long time back. That gives us clarity when this kind of invention is patentable. For example, I can say that a mere software is not patentable. You know, if you write down your coding in a paper and ask me that get me a patent, I can't do that because that is a copyrightable subject matter. What is patentable? Maybe the methodology. Again, if it is only algorithm, it's not patentable. What is patentable? A method of achieving something or method of solving some technical problem is patentable. Yes. The how part, if it is technical in nature, is patentable. Yes. Otherwise, if you talk about only software, it's copyrighted. Some small statistics. I mean, you know, the 67% approx increase is what we have observed. And number of patent application granted is 326% approx. I mean, some statistics just to tell you that we are not at all old India, where people were thinking, okay, should I go for patent or not? If I go for patent, if I go for IP, anybody and everybody can copy it. That mindset is long gone. And people are filing IP, not just in India, but expanding themselves in other market. India is one market. People are exploring US market, European market, even Middle Eastern market, Asian market. People are doing that. And how are they creating monopoly out of through these IPs? Just to summarize the process before filing a patent, ideation is something that is in your mind. I have an idea. What's next? Okay, I write it down. This is the problem. Sorry, I'm trying to solve. This is the solution that I have. This is how it's going to work. This is my how part done. Now what will happen is I'll come into picture, or IP guy will come into picture, and he will do a prior art search. He will do the search in all the public or paid databases to understand if actually it is novel, actually it is inventive, what is the likelihood that it will be granted if we file it. So that is what is, I mean, derived from the prior art search. After search is done, then we go for drafting of this patent application, and then we file it at the patent office. Searches, I'll take 1 or 2 minutes on this because this is a very important topic. Very important. Prior art search, like I said, you come up with an invention, right? You say that, okay, I think it is novel, I think it is inventive, but I don't know. Then we will come into picture, we will do a search. Okay, let us understand it this way. Let us say you want to catch a fish, right? You must know where exactly that fish is in the ocean or in the water body. Similarly, all the patent documents is like an ocean. There are certain classifications, European classification, international patent classification, and another classification which is given by United States Patent Trademark Office. So the entire ocean is divided into small classification. In the prior art search, we identify what is the closest classification to your invention. And then we try to find out what is the closest invention, closest document available to your invention. Then we compare. Then we try to identify what is the likelihood that it is novel. If nothing close to that is found, then okay, it's novel. But if by combination, let's say I find 5 documents, D1, D2, D3, D4, D5, and the 5 feature of your invention are the same as combination of D1, D2, D3, D4, D5, I can say it is novel. But it's obvious because anybody with your knowledge can club them to come into your invention. So that is what we try to identify from prior art searches. Landscape search. The second most important thing is, let us say you want to understand what your competitor is working on. You want to understand the landscape of their IP. We do that. Okay, let's say your 10 competitors, they are filing these many patents and these fields. That is one example of landscape search. Let us say you want to start R&D on battery swapping technology. You're new into the market, but you want to start on that. What you can do is you can start from scratch, or you can do is whatever is available in the market, whatever is available in terms of documents, in terms of patents, you can look into that. And then over and above, you develop your product. So that is one form of landscape search. So maybe you can get 5 documents, 50 documents, 500 documents, 5,000 documents also in terms of landscape search. Freedom to operate search is very, very important. There's a very famous case law here, Bajaj versus TVS. I'll not go into detail, but just to tell you, Bajaj had a patent on double spark plug engine. TVS was about to launch it, but when Bajaj came to know about it, they filed a patent infringement suit on TVS. TVS had to stop the launch. There was a huge, backflow or image loss, monetary loss, and they had to launch that with single spark plug. So, if I tell you in another way, imagine you're walking across a road and you see there's an empty plot. Will you go there and occupy that? No, no. We are smart enough to understand we need to know if it is somebody else or not. If it is somebody else, we will try to buy it, we'll try to rent it, but we will not start using it. It's not 70 or 80 years back when we were seeing these kinds of things in India. It doesn't happen this way. Similarly, in terms of intellectual property, also we need to be sure if we are launching a product, is it somebody else's property? I come up with a methodology of, let's say, enhancing a facial recognition by way of ABC method, and I want to launch that product in the market. The day you launch it, your competitor knows about it and he has a patent, he will sue you. Image loss, your monetary loss, of course, everything is zero. You go to the court and you start fighting in that case. So before you launch a product, better to have this freedom to operate search. Meaning, do you have the freedom to operate in that technology? Okay, patent specification, I'll not go in detail. So the most important part is claims that we draft, because claims is what is examined in view of remaining portions: background, summary, detailed description, drawings, abstract. Claim is what you get a right on. Like in a simple language, if I say, okay, you gave me the entire document, 20, 30, 50, 100-page document, what do you want to claim out of it? Claims are basically a techno-legal language. That's how we draft it. One sentence, one claim. And it has to be read in, I don't know if you have read any act before, you will observe that one sentence is one paragraph. One sentence is sometimes one page. That is how claims work. And that's why it's very important that you draft it in a very rightful way and disclosing all the relevant information. Otherwise, once you file it, if it goes to the examiner will come back to you. Okay, where is this disclosure? How do you do this? How do you do that? You can't add anything new, but you just have to justify. Timeline, I won't go much into that. Once the application is filed, you have to request for examination. Usually after 18 months, it is published, but you can request for early publication. For startups, there's a provision for expedited examination. In usual scenario, usually like 2 to 3 years is the time frame that we see for filing to grant. In case of expedited examination, I have seen cases where the application is allowed within a year for expedited examination. So FER is examination report is issued by the examiner, you file a reply. If examiner is not convinced, 90% of the time I've seen hearing is issued. Otherwise, it is disposed of. Design. Just remember 2 points for design. One is the aesthetic new. Second, is it capable of being sold separately? Doesn't bother of technology. Don't you think about technology here. It has nothing to do with that. It is made up of clay, it is made up of soil, it is made up of polymer, it is made up of this, that doesn't matter. When you look into it, it should be new. Simple example, Tata Nano. When you look into it, it has to be new. Doesn't matter what kind of engine you have inside. Doesn't matter what kind of seat you have inside. Doesn't matter. Just when you look at it, it should be new. Secondly, it should be capable of being sold separately. mobile phone structure. We saw that Coca-Cola bottle, right? When we were having that video, the cold drink one, or we saw the structure of a phone, mobile phone. So all those things comes into design. Where you go for a design, let's say you have a very unique way of a product representation, or you have a very good packaging of it, right? Or you're creating some kind of a box for that, or your product is a real-time product, right? That time. Trademark. Any mark
Recording in progress.
that represents your trade is a trademark. Here, so what you see is word, letter, logo, combination, slogan, tick that we see for the shoe company, slogans, Dil Mange More, combination of mark, McDonald, M of that McDonald, sometimes McDonald as a word mark. So any mark that represents a trade is a trademark. 2 points to remember here is, in terms of trademark, one is it should be distinctive. I mean, your mark should be distinctive. Number 2, it should not be descriptive. If it is descriptive, it is generic mark. You won't get monopoly for it. For example, I can't sell Apple with a mark Apple because it is generic. You don't own it. It's descriptive. So if I say McDonald has nothing to do with burger, but the mark is used for selling burger. Apple is something that you eat, right? But you're selling mobile out of it. So 2 points, should not be descriptive and should be distinctive. Copyright, software you have, coding you have, music work you have, artistic work you have, anything and everything that you have for literary and artistic work that can be copyrighted. So I think I took a little extra of your time, but I'll be happy to
No
take a
issue.
question.
Yeah. So a few questions are in chat box also. You can have a look. Yeah, and then answer that.
Okay.
And if someone want to ask question, please raise your hand so that we can take one by one.
I think I'm not able to see chat bot here.
If I have an idea and I want the idea to be implemented in Europe, Asia, America, should I apply a patent only in India or should it be all over in different countries?
See, IP is territorial in nature. For example, if you apply in India, you have a protection in India if it is granted. If you want to have this thing in US, Europe, you have to apply there also. How it starts is you first apply in India, then you can take priority from that and you can file in other countries. But if you want to seek protection in other countries, you must file in those countries. Okay, the first question is publication.
Does that cost a lot of money or?
It's expensive. Yes, of course it's expensive. So let me give you a brief idea on this. When you file a patent application in India, it may cost you somewhere around 1 to 1.5, depending on the complexity. It maybe cost you less also. Likewise, design is very cheap. Trademark is cheap. Patent in India is comparatively very cheap. Then you go with Europe and US. So just to file, I'm not talking about drafting. I'm not talking about searching. Just to file may cost you around $2,000 to $3,000 just to file. Similar in Europe, if you say somewhere around 4,000 to 5,000 euros just to file, because they are very expensive. India is one of the country which you can say that IP is comparatively cheap, because even if you're startup, you have 80% reduction in official fee, or your individual 80% reduction is there for you.
Are there any organizations that help you fund your patents?
So what people do is, once you have a really good patent in India, they go for funding. For example, they take their idea to investors, and if investors really like it, they start funding it. I also see another case where, people, they file PCT application. PCT application is not so expensive, let me tell you. So once you file PCT application, you get 30 to 31 month timeline for filing the application outside India. Then what they do is they try to explore a partner in those countries. For example, if I say I want to launch my product in Europe, I'll try to find somebody in Europe who want to partner with me. Then I can ask him to contribute in terms of money or invest in the product for that thing. Or secondly, sometimes they want to have exclusive license. In that case, they can pay for that. Also, there are many government and non-government institutes who support these things. Many incubators are there who support in terms of filing when you can show that it is worth of that.
Just I want to add here, if you are in Bangalore, Karnataka government, if you're registered with Bangalore, then Karnataka government support a lot of thing funding for the Indian patent as well as the foreign patent. Okay, there is a good scheme. So you can go to the website of the ITBT ministry and you can see what are the procedure to take the reimbursement, what cost you have already put for the patent. Okay. Thank you.
Thank you.
Thank you. So I have this question, publication patent, how to apply? Publication patent, see, when you file the application, by default, it will be published after 18 months. If you want to go for early publication, there's a specific form for that. You'll have to pay some extra penny and then you can get it published early. It usually takes 15-20 days for the publication once you search for early publication. Rajesh has this question. If person A registered a website address with product name without registering trademark first, can A person claim the ownership of the brand if the B person registered trademark? Okay. So let me tell you this way. In case of trademark, there are two types of application. One is proposed to be used. Like when you apply for an application, you say that I'm going to use it after a year or after 3 months or after 5 months, something like that. The second case is when you're already using it. In that case, we are required to provide an affidavit along with evidences to prove that you have been using this mark from last 5 year, 10 year, 20 year, whatsoever it is. So that will give you a date which is before than you're actually applying. Advisable is, the best case scenario is, if you have a mark in your mind, get a trademark search done and apply for it. Don't wait for somebody else to copy first and then you think about applying it. Let me know if I answered your question.
Yeah, that sounds good. Yeah.
Who files first will be the inventor.
That I have answered actually.
Okay. Right. If I'm building a technology-based product and I'm not sure it is already developed in India or not, then how would? Okay. See, there are certain websites or certain, for example, if I say Google Patents, right? What you do is just type Google Patents. So you will get the database of Google where there are so many patents. You can do a keyword search in that. Like, Boolean, we do A and B, A or B, like that you can do. European Patent Office, they also have a public database. WIPO also has a public database. Indian Patent Office also has that. But it is advisable to get this search done from a professional. Because like I said, it's a sea, it's an ocean where you have millions and millions of IPs, so many applications, China files, so many US files, Europe files. And it's like, it's a strategical approach. How are you searching for that? You can do that at your end also, but advisable it is that you do get it done from a professional.
Some people have also raised the hand. We can take question from Ashok Babu if he is still there.
Yes, please.
Yeah, my question is also written there.
Okay.
For example, yeah. So if we are adding a new feature, for example, a GenAI feature, like a voice conversation to an existing product, can that be as an incremental patent can be considered?
Okay. The answer to that question lies in the same exercise we did, problem
Okay.
solution approach. You say that what is the problem with that kind of technology? You propose a solution. You ask yourself, is it novel? Right? If you
Okay.
think it is novel, of course, we will do the search to identify if it is novel or not. Secondly, it is obvious or not.
Okay.
If it is already there to use an audio-based technology in a
Okay.
similar field, then it becomes quite obvious to use it here also. But
Okay.
if it is not merely providing the audio, it takes something more than merely providing, then it becomes a patentable subject matter.
Okay.
I can give you one example here. Hypothetically, just hypothetically, I'm sitting in a conference room, right? What happens is I have a mic at the center. The mic is capturing the audio from 360 degree. So if
Okay.
somebody is sitting at the left and somebody is sitting at the right, it's capturing the same amount of sound from everywhere. Problem is that the sound quality is not good. I'm recording the sound only. Now let us say somebody came up with an idea that it has provided an audio sensor. So if somebody is speaking from the left side, instead of being a 360 degree capturing thing, its direction to capture will move towards the side where the sound is coming.
Okay.
So the chances of capturing becomes very high, though it's still capturing, right?
Okay.
But that becomes very high. Now, if this thing is novel, inventive, it becomes patentable.
Okay.
But if this kind of concept is already existing in some other technology in similar line, then it becomes obvious.
Okay. But in this similar line, if there is a performance improvements on the same line, for example, the noise cancellation or removal of making the audio more clear, more vocal, more audible. It's like a performance improvement of an existing product. Maybe
Right.
because of a lot of software and technology PCB design. So the addition of these improvements can be patented. It solves the problem of giving clear audio.
Understood. You are talking about problem, then you're talking about solution. What you have told me is solution. Is this solution patentable? Solution, don't go for solution to judge patentability. Go to how part. Noise cancellation is happening, maybe some method in that, right? Some kind of approach is there, some kind of, previously I used to capture audio through A, B, C technique, and then I used to do noise cancellation. Now I'm doing A, having some feedback, then doing B, then having some feedback. Some approach is different. The how part is different. I have to judge that how part, not the end solution. I'm getting a efficient output now, but how am I getting it? Check for that.
Okay.
For easy understanding, you can write it down. Okay, this is the reason why there's a noise cancellation, which is better than what is already existing. Then see, is this how part novel inventive or not? If it is novel inventive, it's a patentable subject matter. Problem is, we try to judge solution in terms of problem solution approach. Don't do that.
Okay.
I can say that I have a really good speaker, which is capturing, which is displaying very good audio. Right? There's an increase in efficiency, so I want to go for a patent. That is not the criteria for a patent. How you're able to achieve that? Ask yourself. Ask this test to that, or conduct this problem solution approach to the how part.
Okay.
That will give you the right answer.
Okay. But the what I understand is the patent is abstract, right? It need not be proven, right? You need not have to build a product to prove it, right? It is just an abstract, right?
So what happens is the requirement says that when you're giving a patent in terms of patent application at IPO, the law says that for a skilled person, it should disclose the best method of performing the invention.
Okay.
It should not be too abstract that a skilled person cannot perform it.
Okay.
That is the criteria. You don't have to have a model. Though there is a law, there is a rule that says that examiner is allowed to ask for a working model. There is, but in 99% of the case, it doesn't happen. They don't ask for it.
Okay.
Technically, it should be right for a skilled person.
Okay. Sure. Thanks.
Okay,
Thanks.
now we'll move to the next this one. I think Rajesh KB has raised the hand.
Actually, I have one more question. So
Yes, yes.
we're gonna solve a problem, a unique method. Okay, solving a problem with unique method that is not been existed in the Indian legal industry. So with AI technology. So will that be
Okay.
patentable? So we are not interested to focus on the technology patent. We are interested to focus on the method which we are gonna solve.
See, methods are patentable in India, let me tell you very frankly. Yep. But we need to understand three things. Same thing will apply here. For that method, you have to identify what is the technical problem I'm solving. There are two types of problem, normal problem and technical problem. Normal problem would be, let's say I have 10 students and I want to write their name in an Excel. It's a normal thing. But technical problem would be I have 10 names, but analyzing those 10 names requires lots of time, lots of resources. So how can I do it in a more efficient way? This is the difference between normal problem and technical problem. So you
Correct.
identify that. Then you go to the solution. Your methodology is the solution, which is giving you an upper hand.
Correct.
Now, in that methodology, like I said earlier, what is the how part? Is it step B? Is it step C? Is it step D? Because method is sequence of steps. Step A, this, step B, this, step C, this, like that, and like that. So you identify what is the core step, the how part, which is actually responsible for the solution. Then, is it technical in nature? Is it providing a solution, the right one? Then you ask yourself, is it novel? Is it inventive, or is it not obvious? If yes, it's patentable. In
Okay.
case of these kinds of AI-based technology, Section 3K comes quite often by the examiner, which says that mere software is not patentable, mere algorithm is not patentable. So examiner would primarily see that a sequence of step is algorithm. But we will have to prove that it's not mere algorithm. We are trying to solve a technical problem here, and the solution is providing a technical effect. Maybe I'm able to reduce the memory consumption, I'm able to increase the efficiency, whatsoever it is. So we'll have to prove it that way. It can be patentable, provided, like I said, three things: problem solution approach, check for technical problem, technical effect. Second, identify the how part. Is it novel, inventive? Third, the output has to have some technical contribution.
Okay.
Did I answer your question? Or
Yeah, you can take from chat box also. And one more hand is there, I think, Saudullah Khan. If you are there, then you can. Yeah.
I have actually a simple question that was answered before. That if I am building some technology-based product and it is already in the market, and if I am providing that solution, same kind of solution to a customer or client, then whether is there any legal implications for that, or I can provide solutions to the client?
okay, there are two scenarios here. One is, you know that the product is there in the market, right? So that product, the IP or the patent corresponding to them, is it owned by somebody? Let us say there is a company A who has a patent and he has launched this product maybe 5-6 years back and it's there in the industry. And he has also given license to his some competitor. Now, if you launch your product also in the market in similar line, you are infringing. Then you may receive a legal notice. If there is no IP against it, there is no patent against it, then you can launch it in the market. Like I gave you the example of freedom to operate search. Do you have the freedom to operate in the market with that product? That you will have to check. I gave you the example of for dual spark plug engine case. TVS, they just launched the product in the market without actually saying that is it owned by somebody else or not, right? So advice would be just get an FTO done, that if it is somebody's patent or not. If somebody's patent is there, then you can ask him for license, or maybe you can do some interaction with them before you launch. At least you won't be having, a big issue, image issue, or, the legal complications in that case.
Got it. Thanks.
Yeah, you're welcome. So if I'm adding a Gen AI feature, say voice, okay, I answered this, and it is hardware, software based, including AI based. Did I answer this?
I think you have answered, yeah.
Nowadays, some products actually include some hardware AI-based features also, like
Right.
NLP
AI
based
is
or
an
computer vision
accuracy.
based. So that features is also included in the product, and sometimes it is novel, or some part of it is novel, not all parts, but maybe some part. But that does.
Sorry, I lost your question. Does what?
Does that include this? Does it come under patentable or not? Like that part, AI based
Oh,
approach
okay.
also.
Approach is same. Approach is same. Right? You can have n number of similar questions, partly disclosed, completely disclosed, 20% disclosed, 100% disclosed. Approach is same, just basic approach. What problem are you solving? Right? What is the solution? What is the how part? Now, is that how part novel? Is that how part inventive? Then it becomes a patentable subject matter. Now, if you say, let's say, I'll take the similar case that we discussed a few minutes back, the listening device, for example. I know a device, I know a mic which is capable of receiving audio from 360 degree, right? The only modification I'm doing is it has a sensor. Whenever it receives the audio, it will identify the direction. It will focus entire spectrum towards the direction where actually the audio is coming. Now, I can say that the only difference is it can focus on one direction, not 360 degree. But recording audio is already known. Capturing audio is already known. Replying is already known. Everything is known, just only small difference. Now, in this small difference, is it novel? The sensor and the entire combination, is it novel? Ask yourself. Is it obvious or not obvious? Ask yourself. If the answer is yes, go for a patent. I mentioned earlier also, nowadays, what we are getting is an incremental invention. And how do we identify incremental invention? Problem solution approach. I gave up a product, there's some problem. You identify the solution. If it is novel, inventive, go for a patent. Did I answer you?
Yes. Thank you, sir.
Welcome.
I think
So there's one
question is there by Mr. Pranav T in chat box.
chat box. Okay. I think, can a patent be filed simply component of PCB circuit? Is it this one or did I answer?
No, last one, Pranav T.
Okay. Can you explain a bit more on the software patent side of things? For example, a product involves some AI-based process to solve a problem. So does it come under a patent or a copyright? And also, how can one have a brief idea if their product will be eligible for a patent? Okay. Two things. One, when you have an AI based or software based, you have a coding, right, to execute your product. That coding is copyrightable. You print the code on a paper, give it to us, we'll file it at the copyright office, copyright done. That's it. For patent, same approach, problem solution approach. AI is working on certain methodology. AI is not as alien terminology. If I can give a feedback loop, for example, if I can train AI or if I can train a model for certain aspect, I'm solving a technical problem. Okay, I'll give you another hypothetical situation here. Let us say I'm using some face recognition model here. Now, when I'm standing in front of a camera without my glasses, it can identify me. When I'm using glasses, it is not able to identify me. I use an AI model, and the methodology here is that if there's any object on my face, it will identify the object, it will subtract that object from my face, and then rework on it. So this is how the AI model is trained. Now, the method, the how part is identifying the object and subtracting from the face. This is the method, though it is done by AI, but this is the method. Now, if this method is novel, inventive, it becomes a patentable subject matter. Just because you're using AI, it doesn't matter if it is, adding what or decreasing what, subtracting what, multiplying what, doesn't matter. Basic concept remains the same. Problem solution approach. Even if you use AI, you don't use AI. What is the problem you're solving? What is the solution? What is the how part? For example, in my case, when I'm using an AI tool, the how part is identifying object, subtracting it from the face, and then identifying the feature. That how part, is it novel, inventive, it becomes patentable. Pranav, did I answer your question?
Okay. So I hope it is a really enlightening session. Okay. Susmita, are you there?
Yes, sir.
Yeah. So, is anyone want to say something or feedback? You can just take few seconds and tell. You can just raise your hand and or you can open your mic and tell us.
Sir, I think so. Intellectual. It was actually a very informative session. So one thing I wanted to last ask about trade secret. What about trade secret? Is it part of IP, right? Did we
It's
touch
part of
upon?
IP, but we don't have it in India.
Oh, okay,
There is
okay.
no law
In
of
India,
trade secret in India. It's there in US
okay,
and many other countries. We don't have it in India.
okay. Only
So
three things
we
in India:
say that
trademark,
you keep
patent.
it safe. As
Okay,
long as it is safe, it is safe. Once it is out, you can't stop it.
okay.
Okay. Any other feedback? No. If there is no further question and feedback, let us thank speaker for really great enlightening session and keeping it up to basic level. That is the more important thing here. Everyone will understand so that their mind will ignite and they can start thinking in that direction if something they are doing and not knowing about that one. Okay. So I think it is really great session. And we will come up with many such sessions for our audience. And I think it will be really useful when they will do such kind of a startup journey or deep tech research or something like that from academia or startup or anything if you want to do. So we will again, let's thanks on behalf of audience to speaker. So Smita, if you have anything to say, please add that. Okay. Thank you. Susmita?
Hello, sir. Yeah.
Yeah, go ahead.
As we concluding our today's session, so I would like to take this moment to thank everyone who made today's session a great success. First of all, big thank you to our esteemed speaker for an insightful presentation on creating awareness and securing intellectual properties. And also, I would like to thank all the audience who joined us today. I hope, uh, I'm sure they have gained some insights about how to secure their IPs in future. So yeah, and also lastly, I would like to thank our Art Path team, their support, and also I would like to thank our director, Dr. Sanjeev Srivastav, for their constant guidance and support in making this event possible, and also our skilling team as well as marketing team who worked very hard behind this scene to ensure everything ran smoothly. Your efforts are very truly appreciated. Thank you once again, and thank you. uh, we'll see you soon, and we'll hope you are joining our future webinar as well. Thank you so much, and happy weekend to everyone. Thank you.
Thank you. Thank you, Susmita.
Thank
Thank
you,
you,
everyone.
Deepika, for right approach, and thank you, technical team, for your support. Thank you, Gauraji.
Thank you so much. Just wanted to say a few words, if I
Yes.
may.
Yes, please.
Um,
Please.
so keep your mind open. Let's more and more idea come into our mind. Let's not be skeptical about these things. And thank you so much for having patience and having me here and giving me this opportunity to interact and give away whatever I have. I'll be more than happy to interact with you. You know my email address. You can connect me on LinkedIn, or you can connect with Diksha, or you can, if you want my number, you can have it from Diksha also, or any kind of help you need. I mean, please feel free, right? And happy New Year to everyone.
Thank you. Thank you very much.
Same to you.
Yeah.
Thank you. Thank you so much.
Yeah, let's close the session. If there is no other